It's Season 3, Episode 6 of the Doctors and Litigation, the L Word podcast. I'm your host, Gita Pensa. Welcome back. Okay, everybody, it's March 2026. I'm glad to have everybody back. Got some good stuff for you this month. First off, if you are a fan of the show The Pitt, I made an appearance last week on the HBO Max companion podcast to The Pitt to talk about the impact of medical malpractice litigation on physicians and other clinicians. I mention in today's interview later on that I had the very exciting opportunity to be a consultant for the show in Season 2 and now again for Season 3. Probably a career highlight. And if you're aware, there is a medical malpractice storyline. So if you want to check out the podcast, I've linked to that in the show notes. I think it's really important for us to bring these conversations to the public because there has been a very one-sided marketing campaign, basically engineered by plaintiffs' attorneys for many, many years. And the public really does deserve to know how litigation affects not just their doctor, but the healthcare workforce and their access to care. So more on that in another podcast coming next month. But this month, I am thrilled to welcome back trial attorney extraordinaire John E. Hall Jr., founding partner at the National Trial Counsel firm Hall Booth Smith, to talk about his new book, Reviving Fairness, Defending Healthcare Heroes. We talk about fairness in medical malpractice and how the system seems to have lost its way in that regard, the pressures facing today's clinicians, and why defending good medicine protects patients too. You heard from John last month in part 2 of The Educated Defendant, where we discussed Dr. Nirav Patel's trial. And so if you haven't heard the 2 episodes leading up to today, I recommend that you at least start there with episode 4 of this season and then continue on through today's interview. You know, in general, I recommend that you start with season 1 and kind of work your way through, but at least this time start with episode 4 to get the lay of the land, the first episode with John Hall, and then today's interview where, without further ado, we're going to talk about some key insights from his book, Reviving Fairness, Defending Healthcare Heroes. Today, I really want to talk to you, John, about your new book. Thank you so much for coming back to talk to us.
No, I'm happy, and thanks for the book. I really believe we've got a lot of opportunities to do some things, and I hope we can get the word out there.
What I'd like to do is sort of start with your closing argument first, I think, so to speak. If you could deliver one message directly to the physicians who are listening to this about their role in litigation and how this system could work with the right reforms, what would you want them to hear?
Wow, that's a big topic in terms of closing arguments, but let me give you a brief version of it. Number one, I think I would start out letting everybody know that we're in a dangerous time in our system. The jury trial system is at great harm caused by certain plaintiffs' lawyers in a group that have this desire for generational wealth to the point that they don't really care about what the facts are, the outcome of what's reasonable, or their clients. I see routinely in trials plaintiffs' lawyers asking in a single injury plaintiff case from a surgery or delivery or otherwise for $100 to $200 to $300 million for one person. It's ridiculous. It's generationally wealth driven. That's coupled, and one of the reasons they're taking advantage of it is it's coupled with a change in our society where people are struggling on individual values and worth and other issues. And so you get the potential for jurors who have a system, and especially as they see medicine becoming more structural and less independent and individual, they have a view to think, well, just let the hospital or the doctors pay it. They're all fine. So you've got those two things converting with a judicial system who's more focused on settling the cases and moving on than they are getting the cases tried and what the true in terms of an outcome. And on the defense side, most doctors and hospitals now, your life is in your hands through insurance carriers and or large self-insured companies that are running your litigation. And in the middle of all that, sometimes we all want to get in a corner and just kind of shiver a little bit. But you've got to stand up. If you want this system to work, it starts with you. Because if you don't stand up and if you don't take your case seriously, you don't get involved and you don't hold your insurance company, your hospital, your attorney, and the plaintiff's lawyer and the jurors accountable by getting up and stating your positions, why you did it, where you did it, and what was right about it in a passionate way, depending on your presentation. Some people are quietly passionate, some are more boisterously passionate, but in a passionate way that you want to know about your case and you want to insist and work toward getting the best outcome. If you don't do that, then you'll get part of the machine. And that's not where we want to go. We have to get control of all those different areas that I mentioned to make changes. And that's what we talk about in the book. It's reviving fairness, defending healthcare heroes. I've had multiple opportunities to be a plaintiff's lawyer. I could own an island in Bermuda if I wanted to, if I went and became a plaintiff's lawyer. But I just could not sacrifice what I believe has driven this generational drive for money to the point that you don't care about care and providers and professionals who are there at 3 a.m. taking care of us and our loved ones. That's why I wrote the book, is I wanted to get the defense lawyers, the insurance industry, the hospitals, and the physicians to really understand that we got to wake up, and there's some aggressiveness we got to bring back to defending these cases, and we can't be complacent. If we stay complacent, we're going to get run over.
All right. Let us get into the book, Reviving Fairness, Defending Healthcare Heroes. I think the audience for the book, as it's written, is really meant for attorneys and people who actually defend healthcare heroes. But I got a lot out of reading it.
Really, one of the key topics is to go to the decision makers, the C-suite claims people that hold the authority in these cases and authorize or don't authorize the lawyers to get to what they do in their defense. That's one of the issues, is to let the people who make the decision to settle and how much to pay understand what we're facing. So it is for the attorneys, it is for the doctors, but that's the group of people that's really got to change their mindset. And I think the doctors can help. When you get involved in these cases, not only do you want to get to know your lawyer, you want to get to know, if you've got a carrier, you want to know who your claims person is, and you want them to hold them responsible, that they're going to support the defense of you in this case, because that's what they agreed to do. And likewise, if you're in a bigger system, you're in a bigger company, your hospital has their own risk management group and their own claims folks, hold them equally accountable to allow you to be empowered to defend these cases and your lawyers to be empowered to defend it. I have one case where, they're asking for $200 million. Many nurses had been named as defendants in the case. I wanted the nurse to be involved and sit through the entire 2.5, 3 week trial. And I got pushback. No, they can't be off the floor. They're just going to come in and testify. And I said, no, they can't do that. That's really why the book's written, is to let us all know we got to step up our game.
I mean, yes, you can see how short-sighted that was when, you understand how important those optics are to the jury, and to say no, we need the floor nurse to be on the floor and then she can just show up and do her part, when the really experienced trial attorney is saying this is the way we win this thing. If you wind up with a $200 million verdict, it seems awfully short-sighted. Your book opens up with talk about the status quo of today's medical malpractice environment. So for clinicians who only really start learning about this world when they're sued, which is the bee in my bonnet, is that we should be learning about this early and we need more education. That's my angle. But for the newly engaged, how would you describe the landscape that we're actually practicing in right now, as opposed to, say, 20 years ago, when you started hinting at it in terms of predatory plaintiff's attorneys' tactics and this era of these nuclear verdicts? What is different?
You know me, I don't use the term nuclear verdicts, because a nuclear bomb is dropped, you're going to have total devastation. You can't prevent it. I call them aberration verdicts. They're predictable and they're controllable usually. The plaintiffs want it to be nuclear, that, oh, this is a nuclear verdict case, you're going to get destroyed, and we all think we're going to get destroyed. I think it is something we can control, so I call it aberration verdicts.
We've heard from Dusty Otwell, and he was the one that told us that the first time, but it didn't stick. So yes, the aberration verdict. I think we talk to each other with this term nuclear verdict, and so everyone knows kind of what that means. But you're right. And one thing I have found working with many lawyers is that the precision of your words matters a great deal to them. So thank you. The aberration verdict.
Right. And I'm sorry, I lost myself in your questions.
How long have you been doing this?
Oh, really? You can ask me. 43 years.
All right. So, I mean, I've been practicing medicine for 25-ish. Okay. I can tell you all the ways in which things have changed in terms of being a practicing. What is different now for the trial attorney? Like, what's different?
The jurors and the plaintiff's lawyers changed. The status quo I refer to as plaintiff's lawyers would come in, evaluate the case, get relatively straightforward experts, and then ask for a reasonable sum. And back in those days, we make mistakes, and most hospitals, most providers, if they can resolve a case that they have some question on the care, they want to do that. And that was true from when I started practicing in the early 80s all the way through the late 90s. And I started seeing it change around 2000. And a couple of things, these exaggerated damages that they were making through these fictitious life care plans, putting up numbers for future care of $100 million or those sorts of things, based on plaintiff's attorneys wanting to be able to drive a huge verdict that would go in. And in the old days, when we tried these cases, we won 90% of the cases we tried, and we tried 20% of the cases. Nowadays, less than 3% of cases are tried. And of those, we still win 70 to 80% of those cases. But when you lose a case, you have a chance for it being an aberration verdict, because instead of asking for a reasonable sum of $200,000, which somebody's got 30,000 in expenses and some issues, plaintiffs lawyers now would ask for 10 million, or instead of asking for a million, they ask for 100 million. And the defense in the old days would not put up those damages defenses, because they thought, if I talk about what the reasonable damage is, then that's going to lessen the strength of my defense on standard of care and causation. And it's just the opposite. If you don't talk about these ridiculous numbers that the plaintiffs are putting out there, the jury, if they find against you, may cut it in half and may cut it in a quarter, but it's still so ridiculous that it's still an aberration verdict. You don't weaken your liability or your standard of care defense, because if you show how ridiculous these damages are, and for instance, you take somebody, in some states they have a return rate is 5%. So you take a child that's got a life care plan and you say, okay, if we take 5% of that money annually and it earns this amount, that can go to care. And by the way, that's more than the average care is already on this. Versus if a plaintiff's lawyer gets up there and asks for $100 million, then the lawyers don't point out, folks, $100 million, you put it in 5%, that's $5 million a year every year without ever touching the principal. And when you show and underline how ridiculous and how stretching they are on the damage, that then raises the credibility question of them and their experts on whether the standard of care was violated and did it cause any injury. So by taking this holistic approach, we question the credibility of plaintiffs. And I get in trouble with lawyers this way, so forgive me, and hopefully this is mostly doctors. I'm a bad believer in legal organizations. Plaintiffs lawyers going and walking up to the bar back in the days of where they'd go up with the defense lawyer and they all go drink after the trial. The plaintiffs lawyers are the ones I deal with on these generational wealth world. They are just despicable human beings who don't care about anybody but their own money. And I'm not going to go socialize with them and justify that behavior. I believe that behavior is a core existential question to the litigation system that we have to push back about them. And being their best buddy is not the way to do that. And by the way, they are so absolutely aggressive. They'll take that best buddy and they'll threaten them. They'll threaten to take their firm. They'll threaten to sue them. They'll sue the company. And all of that psychological warfare that they are training on both the doctors, but also the claims people and also the lawyers. We've got to be back so that we push back against that. And that's why I'm saying the status quo has got to change. It's not just the good old boy network of just go, hey, it's worth 10,000. Well, can you get it for 8? No, but give me 10. No, but we'll do it for 9. Nowadays, it's I don't care. It's worth 10,000. I want 200 million, and I don't care about it.
I mean, I think the business model of plaintiffs' firms has changed a lot over the last 20 years too. And I know that the plaintiffs bar works together. They all learn from each other. They're kind of good at teaching everybody their strategies, their tactics. Now we've got third party litigation investors in there. There's this is a big money model for them. This is like a bajillion-dollar industry for them. What you were just talking about in terms of the psychological warfare against not just the doctors, but the claims teams and the lawyers who are involved, all of that. You get really granular about this in the book, but just greed. Greed corrupts this whole system. So let's talk about fairness. For you, when you talk about reviving fairness, what does fairness look like in this system?
Fairness is looking at cases from the correct standard of care, not plaintiffs' lawyers will ask a jury pool, do you believe the people that manage this courthouse should do everything possible to keep you safe? And they ask those questions in voir dire, and many of the defense don't object to that. What they're doing is changing the standard. Should they do everything reasonable to do everything to keep you safe? And they start doing that with doctors in depositions. Doctor, don't you do everything possible to keep your patient safe? And doctors, well, yes, I do. Now all of a sudden they've committed themselves to a standard that's not reasonable, but perfection. And the plaintiff's lawyer just put them in a trap if they weren't prepared to stay out of it. What we have to do is get back to a reasonable standard. In other words, the question is, was that care so bad that it was unreasonable under those circumstances? That's how we've got to look at these issues and get them out there. First is to get the standard back and get the standard normal. And then that same reasonableness has to apply to the damage side and to the causation side. Hey, you may have done something wrong, but it didn't cause the issue. And we've got to get juries and lawyers more aggressive at demonstrating. Cerebral palsy is one of the key areas. There's an article out on the New York Times in the last couple of days.
Oh, about the fetal monitoring.
Fetal heart monitoring has never been proven to do what it says it does and what the plaintiff's lawyers say it does. And it is not predictive in the way they say it is. And what we've got to do is get back to the science and to get our physicians who get to offer the expert opinion on this to be honest about what the science can show. And in cerebral palsy cases, we're going to discover over the next 5 or 10 years, the role of genetics is so huge and so still underreported. And so many other factors from infection, from placental insufficiency, from mom's illnesses, all are those complicated causation questions that if I'm representing an OB, I need to go out and get placental infectious disease. I need to get neonatologists. I need to get potentially pediatric neurologists, pediatric nephrologists, all those placental pathologists to go in and develop that causation defense to show that it did. And then we've got to be reasonable on the damage side. I call it doing the whole case and developing the whole case and keeping it on the regular standard of what reasonable conduct is, because the plaintiff's bar is venture capital. Third party funding, for folks that don't know, that's venture capital figured out it's better to go invest in lawsuits than it is multifamily housing. They come in and finance these cases because 98% of the cases settle. They know they're going to get their money back. Think about this for a plaintiff. You're a plaintiff in a med mal case, and it's a significant injury. They have a 50% fee. Of that 50% fee, they don't pay any of the expenses. So if you get $100,000, $50,000 goes off the top then. If they spent $20,000 getting that $100,000, that comes out of your 50. So now you're down to 30. And by the way, if you funded the litigation by getting funded your expense beyond just the expenses of the litigation by getting a litigation finance company, then they get their cut. And the plaintiff gets nothing in this system. And most plaintiffs don't realize that.
I'm sure they don't. And it's amazing because plaintiffs' attorneys have done this. I mean, hats off to them, I guess. They've done this really great marketing job where they have branded themselves as the savior of the common man. Like they go fight big business, they fight big insurance, they're going to get you your money. And the plaintiffs don't know that they take almost all of it. Like they take so much of the money. I don't know at what point they're required to disclose that to the poor plaintiff, but certainly you could lure them with the, hey, I'm going to get a $200 million verdict here. And like, you'll walk away with $10 million. How does that sound? But I mean, but you see how it happens.
No hats off to them. They are evil, those that follow this generational wealth chasing of plaintiffs and are destroying our system. And I think it is go look on television, go look on billboards. They bought into Madison Avenue. They are, through their groups, putting together a combined way to influence jurors. And they're doing it by showing it on television, by showing it on the billboard, by showing these issues and talking about the issues. And one of the concepts is I think the defense has to get better. Imagine insurance companies, okay? Insurance companies represent doctors and they come in and get great for premiums for them. They make money off of this process, which is fine. They need to make money because they provide protection for risk. But instead of going out and putting out some commercial where you got some buffoon standing in front of the Statue of Liberty talking about liberty, this or that, the other, instead of the company spending these stupid public relations, going to hiring a golfer or a basketball player making tens of millions of dollars, or a football player who's representing your insurance company and thinking that juries don't think you got more money and just the insurance company is going to pay for it. Why don't they spend all of our advertising dollars on educating the public about what our healthcare heroes do? Who's there at 3 in the morning? You want to advertise, go show a story about how this physician worked their way through school, became in this position, and were in the hospital that night and saved the mother's life. But unfortunately, the baby, because of the mother's placenta or other issues, had issues. And now we want to hold the physician responsible for all of that.
Again, also completely, we talked about your songwriting. Like, you're absolutely singing my song. I actually posted something not long ago. I don't know if you ever watched the show The Pitt, but like in emergency medicine, especially, we are crazy about the show The Pitt. The nation is crazy about the show The Pitt because it won a bajillion Emmys. I'm going to say this right now. I got to consult on something for season 2. I'm not going to say anything more about that, but you might be able to guess what that is because I got to come in as a consultant. But the reason I think that Americans love The Pitt is that it shows competence in action, and it shows these doctors working as a team. And it's just so refreshing to see a team like really work together. And this is actually what we do every day, but we don't see it portrayed. All we see now on social media, on TV, or whatever, are all of medicine's failures. That's all we ever see. And the public is certainly getting the message that they can't trust their doctors, that they can't trust modern medicine, that they have to go seek out some naturopath because why? Your doctor doesn't listen to you. All in the New York Times, any single paper, any single social media, it's all about how bad we are. And it drives me berserk because when that trust gets eroded, what fills that gap, like people profit off of the mistrust of doctors, and certainly plaintiffs' attorneys are a group of people that profit off of that mistrust, but also like all of the influencers and this whole wellness industry, all of this, they all stand to gain by making us look bad. And we have to figure out how to get our narrative of competence back because we need the trust of America. Oh my gosh, I'm going off on a tangent, but yes, you are totally singing my song.
Well, let me give an example because you've got such a big audience on just a very microscopic view of how a doctor can do that. You're a doctor, you're called for jury duty, and you're sitting out there with 40 citizens, and you get up and you decide. What I find is most physicians don't want to be there. And so they get up, well, I got patients and I can't be here. And they're saying this among 40 or 60 other people, hearing them talk about, I'm too important to be here. And judge, won't you let me do it? And if the judge won't let them out for that, then they plaintiff's lawyer ask them the question, well, as a doctor, I'm sure you would tend to lean toward that profession. Absolutely. I cannot be fair and impartial, even though I'm a citizen and I live in this country and I say that I'm going to be fair and impartial. I couldn't be fair and impartial and I would decide against you. So they get struck to go home. So if doctors, nurses, if you're out there, your constitutional duty is to be fair and impartial in these and to make yourself available. Please do that and quit trying to get out of the thing and ruining my jury panels by looking like either a jerk or looking like somebody that's arrogant or coming up and saying you can't be fair. And if you can't be fair in that part in life, I don't want you to be my doctor, because it's going to be
I've
tough.
never thought about that before. That's a really hot take. Okay, I get it. I'm sure that all of us have tried to get out of jury duty at some point, but perhaps next time I will not. I see what you're saying. Now, in the book, you talk about sort of pretrial maneuvering. You talk a lot about, venue shopping and manipulation of discovery and all sorts of other dirty tricks. I want to ask you about something that I think really harms defendants, and that is all these pretrial or even just early in the case, they go to the press. They sort of leak a lot of information. They have people write articles. The articles, they help promote them on social media. I have so many coaching clients right now who have been referred to me because they are under so much distress because there's been this like smear campaign and they name the doctor, like all of this stuff. And I know that this is all part of that psychological warfare, as you called it. But I hear over and over again this complaint of, I don't understand why they can go out there and say all these things about me, but we can't say anything. I can't say anything to defend myself. I can't say anything like, actually, I did do everything right. We're going to show XYZ. Most of the time, it's met with absolute silence, and the silence is really deafening. For instance, this Take Care of Maya case, this all children's Florida case, which I hope to talk about at length at some other point.
Yeah, the verdict was reversed on that case.
As it should have been. So I spent a couple of days with the staff before that happened, like in the aftermath of the verdict. I got to hear about this case and everything. And I know that everybody in that hospital did everything to save this kid's life. It was amazing. But I also heard that the documentary that became this big Netflix hit, which was released well before trial, the plaintiff's attorney brought in the documentary team. I don't know what the funding shenanigans, whatever, but somehow that guy is the guy that came in with the film team to make this hit job piece. What can we do about this? I don't understand. And one of the biggest complaints of the staff at that hospital was nobody said anything to counteract it. Nobody came out and painted us as the good guys. We just took it. We just had to take it and take it and take it. And we don't want to take it anymore. So what can we do?
That is a very hard area to deal with. First of all, other than a few cases, publicity ultimately doesn't make a difference in the courtroom. You're able to go through and deal with that, other than the general perception that you and I have talked about earlier that jurors are starting to have in that point of view. I do think the time of no comment is over, but we have to be careful because what you say, you've got to deal with, they're in the righteous seat of, I've got an injured person and I'm doing this. You've got to be careful how you do it. And I think that there needs to be a strategy early on. This really only affects less than 1% of cases where there's any publicity at all.
I don't know, maybe I have this really selective group, but certainly I have a number of clients who it's not something in the paper, even if it's the local paper, or the plaintiff is posting things on social media about them.
Again, if the plaintiff is doing that, we can discover that and we can use it against them at trial. Just like if you were to do something on social media about the plaintiff, they could find it and use it against you. But I do think there needs to be a conscious point of view of being able to say, hey, we certainly feel sorry for this person and their condition. However, the care that we provided was the appropriate care, met the standard of care, and we're going to look forward to our ability to go and prove and show that in court. Have some sort of a way to get that message across. And if it's a barrage of a case, I've been involved in many cases where it's been a barrage. We do have a team usually in those cases to come and do some sort of a campaign back. But what you have to be careful is that campaign's not led by hospital administration or others. If they don't do this under a lawyer's guidance and do it, everything they talk about with the public relations company now is discoverable in the lawsuit. So when they sent the first statement that they didn't do anything wrong here, well, let's mark this out. All of that becomes discoverable. You've just added another 15, 20 depositions to the case for the team that put that together if it's not done in an appropriate way that's protected and set by privilege. So there has to be some understanding of doing that. I wish there was a better mechanism for it, but unfortunately, I don't believe we're going to be able to win the battle with newspapers, with TV stations, and others because the good story is not from their perspective, the doctor did everything right. They just spin it a different way.
I mean, we have such strong feelings. I mean, this is one of the things that tortures us, right? Is our reputation is everything. And when we're getting completely destroyed in the press, we don't deserve it. And it really adds to the stress of the defendant in a way that actually I believe gets dangerous. And I don't know what we can do about it.
Well, I think, first of all, if it's that kind of case, I think both the doctor and the defense team have to recognize that it's out there on that case. Then we have to get back to where we started earlier is they got to start asking some questions of each other. Let's get in a meeting. Let's actually talk about this and then develop a strategy that is protected, do that in a protected environment, and then have an agreement on developing that strategy. And here's what it is. So I think there's ways to do it, but it is going to require that engagement that we've been talking about. The last time you and I spoke, we talked about Dr. Patel and his sense of engagement in his case. And I think that's the kind of engagement that when people see that, instead of going home and getting in a corner and being concerned, they need to go see their lawyer. Okay, what are we going to do with this? Let's get the claims person on the phone. Let's get the hospital claims person on the phone. And I want to understand what the strategy is going to be.
I think that a lot of us don't feel empowered to do that. I mean, doctors, especially employed physicians, sort of feel like they can't. It's like speaking to power or something, like they don't want to make demands. But what I keep hearing from you is that it's time to make demands.
Well, I tell people in prepping them, one of the things I talk when prepping them for trial or for a deposition, I'll say, think of this. I need you to bring that attitude to you when you have a problem patient or a problem relative in the room. If you sit there and let that relative just run all over you, you're going to interfere with the ability to care. But you don't. You say, stop. You're going to leave the room, and here's what we're going to do. You take control. You got to put on those pants and bring those into the legal system.
Yeah, it's hard when you don't know anything, and you're so afraid. But I really appreciate your saying that. And I'm hoping that when people hear it, that they find that empowering.
And I do think your movement, and I'm a disciple and want to join in there, is medical schools ought to be teaching this. We're to be teaching it in fellowships. We're to be having in-house training on this for hospitals, doctors, and people in big groups. So please keep pushing that baton.
Yes, absolutely. And of course, there's the LEAP course. I can't not plug that. But we need more educational materials around this. Like, people need to learn how to navigate and empower themselves in it. Okay, I want to shift gears. You've got so much great stuff in this book. I want to ask you about negotiation, right? So most doctors don't see the negotiations happen. They don't know what's happening. They don't see their lawyers sort of advocating for them in these scenarios. Like, what are the biggest misconceptions that physicians have about settlement negotiations?
That they don't have control, or they don't have the right to understand or know what's going on. First of all, if you're a medical professional and you're sued, you have an absolute right to know that everything that lawyer writes, does. The lawyer, even if they're hired by the insurance company or the hospital, their first ethical duty is to you. The first thing you ought to do when you meet them, and I offer this, and we do this as a matter of routine, unless people tell us not to, I copy you with every report I do. I copy you with every report to the insurance company and to do those, so that if I get the demand or the claims person gets the demand, they're going to talk to me and them, and we're going to exchange communications about that. You have a right to get that communication. And I tell you, I'm going to give you copies of my report, and it may say, hey, when they were doing this, that's a problem, and we got to find a way to fix it. And you've got to understand to me that I'm looking at the case fully. And if you're going to get these reports and read them, you've then got to pick up the phone and we got to talk about how we're going to deal with that. Or if I say, the doctor needs to work on being a better witness, I'm going to say it and copy you with it so you know it. I'm going to tell it to you when I see you, and we've got to work on it. They have absolute access to all of this information, and you have to demand it. Once you know that you can do it, there's only so long you can stand in the corner and say, well, I don't know what to do, and I don't have any control. It's time for you folks to stand up. You have control. Go exercise it.
That is so true. But I think that many physicians, because they're so traumatized by the thought of litigation, by being a defendant, and I was this way, I would go into a tailspin every time I would get a communication from my attorney. And a lot of times, way back then, a lot of it would come in the mail. But I wasn't emotionally capable of handling it or receiving that information. So some doctors, I'm sure, will say to their attorney, like, I don't want to hear anything unless it's something I got to do. I think we've sort of gone over many times now at this point why that's not a helpful attitude. But the first thing that we have to be able to do is to handle our emotional distress around this, because that's the only way that we can get into this strategic mindset. And this is what I do a lot of coaching around. But yes, really, you do want those communications. You do want to understand them. You do want to know what's happening. If you are in a place where you cannot deal with seeing the emails, then we've got to work on that.
There are folks like yourself and even psychologists and others that will coach on dealing with that concern and that issue. I mean, it's a victim society. At some point, if a victim wants to fight back, they got to stand up. They can't just be a victim. And we all get into that position. But the good thing is, because of the way things have evolved in the last 5 to 10 years, every hospital that is supporting defenses or physician group or insurers have a program. If you ask and say, I want to have somebody to meet with me, talk with me, and prepare it, I want to have Gita or somebody to do that with me, they will pay and have you do that if you ask for it. If you don't ask for it, hopefully your lawyers told you, if you need this, we can get it for you. But if you ask for it, you can get that. I think, listen, life is tough. Life is hard. I wonder sometimes, I go around when I'm trying to fill out a form, how 95% of our civilization gets through things, because it's hard. But we can either say it's hard and get in the corner and say, yeah, it's hard and poor pitiful me. But at this point, this is key stuff. It's key to the litigation process, the system. It's key to medicine. But more importantly, it's key to you. And at some point, you've got to find whatever you need to give you the ability to participate in a way that's going to allow us to push back.
I want to shift gears again. Hear many, many, many times from physicians. I just did this group coaching with a bunch of co-defendants in a case, and they did win, and we had a debrief afterwards. Every single person said I didn't understand how important deposition was. Nobody really prepared me for deposition. These words came back to haunt me at trial. We spent so much time all about, wow, I had no idea how my deposition would be used. Plaintiff's attorney just wrote a book called Deposition is Trial, which I'm sure you're probably familiar with. Deposition is trial. But I find that many, 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 many defendants are totally inadequately prepared for deposition. And I know that you're often getting involved much later in the case than depositions. Depositions are done. What would you think would be ideal in terms of preparing a defendant for deposition if deposition is trial?
A deposition is trial, and it's changed so much nowadays. It used to be in the 80s, 90s. The rule was listen to the question, be sure you understand it, answer it directly, yes, no, or I don't know, and don't volunteer any information. That literally was the way when we were trying those cases. That was the instruction
That's
people
still
would
the
get.
instruction a lot of people get. That's it.
That instruction's gone. Now the deposition being videotaped. And if you go there and you're asking a question, plaintiffs can play that videotape in different ways in different courts, depending on. But if you're up there, the lawyer says, well, you did this. No. And you did that. Yes. And you did this. Yes. And most of them, they'll figure out a question that there's a way, if you're not really digging into it, you're going to answer yes to. And they'll get up there and say, yes, yes, yes. So what you have now is the lawyer. In the earlier podcast we did, I said Dr. Patel couldn't get up and speak for 45 minutes. Well, that lawyer just spoke in your deposition for 45 minutes with you saying yes or no, and he gets to play that 45 minutes in front of the jury. So you've got to be prepared, and defense lawyers have to step up. And that's part of what this book is. Because of your focus, we've been more focused on the doctors and what their role is, and I'm encouraging them to be active. But really, I believe the people that's got to get active is the defense lawyers. We've got to stand up. We got to quit being complacent. We got to still think, oh, we're just going to walk through and the case is going to settle because 97, 98% of them settle. So we're not going to go up. Doctors need to be set down. They need to know the case. There need to be multiple preparation questions. You need to be able to ask questions during that process. You need to be put under a fake cross-examination that's videotaped, or if not videotaped, at least it's witnessed and you're discussed with it, you break down, and you need to go through that process. I need to be harder on you in the preparation for that deposition than the plaintiff's lawyer is going to be in the deposition. I mean, around our firm, one thing we try to get people to say, we want everybody to say when they walk out of the deposition, we want them to look at the lawyer that prepped them and say, you were a lot harder on me than the plaintiff's lawyer. It's got to get to that level. And there is a problem with complacency on the defense side and other issues and timing and controlling to do that. And that's part of what we're working hard. I don't expect the physicians of the world to change it, but I do expect the lawyers of the Lord to change it. And I'm beating that drum as loud as I can.
So, all right, for anyone who's listening, who's got their deposition coming up and they don't feel like they got that kind of preparation, you can just bring this in and tell them John Hall said, I need more preparation than you're giving me.
Absolutely.
Everything hinges on the deposition, and especially when you've got a shared defense and there's one defense attorney who's handling multiple defendants. I understand that takes up a lot of time, but it's important.
I'll give you one story to this. I got brought into a case 6 weeks before it tried up in Nashville, Tennessee several years ago. And it was a delivery case involving a nurse. And the nurse admitted standard of care violations in the deposition, like 5 or 6 standard of care violations. Well, that nurse, she didn't violate the standard of care, by the way, but she admitted that she did.
When you say admitted, to us, that means an admission of guilt. We did do that. When you're saying admitted, you're saying something different.
Well, what I'm saying is I've got you on cross-examination and I'm asking you a question. After you've been there waiting 4 hours to start your deposition, you're 6 hours into your deposition, you're 9 months pregnant, and nobody's giving you any instruction other than to read the record and be prepared to do it. And the plaintiff's lawyer's got you at that point and says, isn't it true at that time you should have went in and saw the patient? And the nurse is just beaten and says, yeah, I should have went in. Well, doesn't the standard of care require you to document that? Yes. No, the standard of care doesn't require you to document everything. So we took that case and we prepped her and we went through, and this one's on videotape. It was a trial that was videotaped as the official record in Tennessee. So the plaintiff's lawyer is sitting there and the nurse is saying, yes, sir. No, I said that in the deposition because he said, didn't you say in the deposition you should have done this? Yes, sir, I did, but I was wrong. In that deposition, I said, and that's not true. Ma'am, are you changing? Yes, sir. And he just started beating on her. And she just was empowered, ready and prepared to say, stop. You got in the deposition. You had me for 6 hours. You pushed me on these questions, and I made a mistake. I'm not normal in taking these depositions, but I gave this patient good care. And when I did this, I did the right thing. We ended up getting a defense verdict because that witness was willing to push back against mistakes. And let me stop that, because sometimes it's not mistakes. I can't tell you the number of people we prepared. They get in a deposition and somewhere in the middle, they just say something stupid. They just come up and say, yeah, I should have done that. Or, yeah, it would have been better if I'd have called somebody else, about themselves. But what's even more often, well, yeah, and this doctor should have done that. They start pushing the blame out, even though they've been prepped. At some point, you've got to take responsibility. So I'm back to you doctors now. You've got to take responsibility to stand firm with us.
Yeah. Actually, we have a whole podcast on finger pointing. That it's a big problem. We definitely need to talk about it, because sometimes what's instinctual is not helpful for us. So just sort of wrap things up. Again, I encourage everybody, doctors and defense attorneys, claims people, I encourage everybody to get the book, read the book. What do you think, if we could sort of distill, we've got a wish list, I think, that includes we wish that, legislation, we wish that doctors had time and the energy to do all this stuff. And we wish claims attorneys would assign infinite amounts of money to preparation, all the stuff. What are the things that we can actionably do today to start pushing this in the right direction?
Start before the lawsuit. In your practice, realize that patients feel segregated from the system. They don't feel that their doctors pay attention to them or listen to them. So start by paying attention to your patients. Most doctors, if they have a good relationship with the patient, even if they commit malpractice, the patient won't sue them. That's been proven. A doctor down in Vanderbilt did a 25-year study on why doctors get sued. And doctors who have a great relationship do not get sued. Secondly, in this day and age, documentation is important. Quit cutting and pasting some history that you don't know if it's true or not into your report. Quit just cut and pasting, and quit not taking time to understand and look at what the record is. And there's a number of things on that. So I'll call that the front end side. But on the other side, it is prep for your case. Be prepared. Be the Dr. Patel of the case. Want to spend time understanding. Insist that your lawyer engage you and assist your lawyer in doing your defense, and hold your lawyer and your claims people accountable to pay attention to you. Because I guarantee you, it is so rare that somebody speaks up. If you will speak up, it will send a wave through that entire file, that law firm, and that claims department, that you will become the child that they take good care of, because so few people, the squeaky wheel does get the grease. And then the other part of it is policing your profession, as we talked about earlier. Start looking at experts. And when you're an expert, be reasonable. Don't get influenced by the money or what the plaintiff's lawyer or the defense lawyer wants you to say. Say what's really true using the right standard of reasonable conduct. I'll switch over to, if you're a defendant, we've talked about being prepared. If you're not a defendant and you're the jury pool, tell people you can be prepared, listen, and make a reasoned decision, which you can. And obviously, if you really can't be fair, that's one thing. But I'll tell you, you're not doing yourself any favor by standing in front of the jury pool and tainting the whole pool for whoever's left in the case going forward. I wish there was a silver bullet and we could do this and we'd all skip down and have it. This is going to be one step at a time, over and over, pushing back against an onslaught of people who are so influenced by gaining generational wealth that they're going to push back with you with everything they've got.
All right. Well, we've got to do it, though, because we can't let things continue the way that they are continuing. And to be in this predatory climate helps none of us. But we really can't, like you said before, just be the victims in the corner and just letting these people beat us up and take our lunch every day. We need to push on the things that we can push on. I am, again, asking everybody to go to their professional societies, find out, what do you do about rogue experts? Can we build something into our system that has more teeth? What can we do? And that's up to us. That's our house. We can clean up our house and let John work on cleaning up the other houses.
Again, I think we'll do it together.
That's right. That's right. Let us do this together. And I look forward to more collaboration between medicine, law, insurance. We've all got to team up together to make this right, to course correct.
I agree.
But thank you for this book. I encourage everybody to read it. You will learn a lot. You should read all sorts of books and empower yourself. John Hall, I am so happy to have had you here to talk about this. I hope to have you again sometime if your schedule ever allows it, if you're not on trial.
Please do. And thanks for the service that you're doing. You're helping get the voice out for those folks who need to have somebody to give them that little bit of encouragement. So thank you.
Thank you again, John E. Hall Jr., for your time and expertise. I've put a link for the book Reviving Fairness, Defending Healthcare Heroes in the show notes. Please help spread the word about the book and also share this episode with a colleague that you want to bring into this conversation. It's time to course correct, and we're going to need all hands on deck. We're going to be back next month to talk about the weaponization of punitive damages and the healthcare crisis in New Mexico, and you won't want to miss it. See you then.